Hey everybody, thanks for coming back to Investing in Oregon. Tips, tricks, deals, insights on how to be a better real estate investor, whether you're a real estate broker or a wholesaler or somebody just getting started. We want to break this down because today we're going to cover the sequel to Is Wholesaling in Oregon Illegal? I shot a video about a year ago, got a ton of comments, a ton of views, and I wanted to follow up because yesterday I had the opportunity to sit in front of an attorney who broke down everything a wholesaler needs to know about this new law that's going in effect July 1st, 2025. So what did I do? First, I want to start by saying, hit the notification bell, like my channel, please comment below with any insights or questions you have. We want to be a collaborative community to be able to provide you value and be able to have people share their comments on what we see. It's all about that in investing in Oregon. Now, let's break this down, guys. Effective July 1st, 2025, one thing I want everybody to understand is now you're going to have to register with the state and pay $300 just like a real estate broker did when they first got their license. That means that you need to have a GED or a high school diploma. You need to have your fingerprints and a background check done. And at the end of the day, you need to be able to disclose that you're a residential wholesaler when dialoguing with sellers. Okay, just like I do as a real estate broker, I have to disclose that I'm a real estate broker, whether I'm selling my own investment property or I'm turning around and working with a client. Disclosure, disclosure, disclosure. And that's going to be the name of this conversation as we break through this video. But as of July 1st, you have to pay your $300 and submit an online application, provide your name and names under which the wholesaling will be conducted, business names, i.e. DBAs, and then pass a criminal records check and pay the $300 registration fee that I've already mentioned. Registered wholesalers must renew their registration by June 30th each year for $300. So this is something you're going to continually have to do each and every year. Now, before we go into that, I want to talk about residential property wholesaling, defined as the marketing of residential property where the marketer has only an equitable interest or an option to purchase. And at the time of the marketing, the marketer has held such interest or option for fewer than 90 days and has invested less than $10,000 in the land development or improvement costs associated with the residential property. So what this means is there's a 90-day threshold and a $10,000 threshold to anybody who is doing residential property wholesaling, okay? Also, I want to talk about equitable interest versus actual having legal interest in the property. The difference, equitable interest means that you have equitable interest in the option agreement if you're selling an option, or the assignment of that contract, or your right to assign that contract as a wholesaler, meaning you do not have the name of your company or yourself as the deed owner or the seller of that property because you physically and legally own that. All right, that's a big thing to understand. A lot of people are giving me questions about that. Holding time and also the investment into those deals. That's going to be able to have those time restrictions or the monetary value restriction on what they're trying to do is regulate wholesalers that are holding properties for a quick amount of time, less than 3 months, or having less than $10,000 in the development or improvement costs associated with that residential property. Now, that being said, now let's talk about disclosure. There's basically 5 major bullet points that you need to understand, especially as a real estate broker. Now, residential real estate brokers do not need to get the wholesaling license. They can actually represent a wholesaler, or if they own their own investment business, they can partake in investment wholesaling, residential wholesaling, but they need to disclose that they're a real estate broker, both to the seller that they're buying the property from and any buyers that they're actually going to sell that contract to. So if you're a real estate broker, those are the rules there. But in written disclosure to potential buyers, you must disclose that you're residential wholesaling to any potential buyers before entering into a contract for a wholesale transaction, and to any potential sellers before entering into a contract for a wholesale transaction. Also, to any broker or principal broker assisting the wholesaler in marketing and listing the property, to any broker or principal broker assisting a potential buyer in purchasing that property, and in any advertising related to the property. Advertising on social media is exempt if the links to a separate page within the required disclosure, which means you must have a link. So think about this. When you do a post on Instagram, there is no link in the body, but you're going to have to put a link. They can copy and paste it and be sent to the right disclosure. Okay. A disclosure must be in at least 10-point bold type and must include a statement that the wholesaler or business name under which the wholesaler conducts wholesaling is a residential property wholesaler and will have or has only an equitable interest in the property being sold, will not have or does not have legal title to the property and therefore may not be able to directly transfer the title to the buyer, might not be licensed as a real estate broker or principal broker and therefore might not be permitted to engage in professional real estate activity, and might not be licensed appraisal specialist and therefore may not be permitted to provide an opinion as to the value of the property. Guys, that's a lot to swallow. But what I want to tell you is that it's all about equitable interest, not actually holding deed of the property. It's also about telling everybody that you do not have legal deed to that property so that you cannot specifically sell it. You're selling the contract. Also, making sure the disclosure is there in terms of a real estate broker and the valuation disclosure that you cannot provide them true market value because you're not an appraiser, all right, or a real estate broker doing a broker pricing opinion. Now, that being said, I want to take it a little bit further. A wholesaler may assign equitable interest to another party prior to closing for profit. A seller or buyer who enters into a written contract for a residential property wholesale transaction may cancel the contract without a penalty by delivery of a written notice of cancellation anytime before the 12 midnight at the end of the third business day after the receipt of the residential property wholesaler written disclosure. The right of cancellation may not be waived. Upon cancellation, all earnest money or deposit shall be returned to the person who provided the earnest money or deposit. Now let's talk about this. There's been a lot of wholesalers out there with non-refundable earnest money. That's going to change, especially if they did not provide disclosure and especially if they didn't get through those 3 business days before 12 midnight at the end of the third business day after the receipt of the residential property written wholesaler disclosure. So there's going to be a timelining thing that you're going to want to figure out if you're a wholesaler, which means if I go into contract for the seller, I'm going to want to wait 3 full business days before I go out and try to find a buyer because your seller cannot cancel now. It's always going to be the case that you're going to need to always know timelines in a transaction. But I'm bringing this up because a lot of people don't understand this, and that earnest money that seller was provided is non-refundable back to the wholesaler in the event that they do not provide them the disclosure. So this is a whole different beast or animal if you don't know timelines and you don't know how to get things signed, specifically whether you're using DocuSign or any type of electronic signature system, or you have a wet ink signature and knowing when the calendar days started. Very important. If a residential property wholesaler fails to provide a residential property wholesaler written disclosure to the seller before entering into a written contract for a residential property transaction, the seller may terminate the transaction at any time. Keep that in mind, guys. That's huge. Huge, huge, huge. An escrow agent may disperse the earnest money or deposit to the seller without the need for a separate written instructions from the residential property wholesaler if the seller in writing asserts that the residential property wholesaler written disclosure was not provided to the seller before entering the written contract for the residential property wholesale transaction and demands disbursement to the seller of all deposits held by the escrow agent, and the seller has provided the escrow agent with a written release and indemnification against all liability arising from the disbursement of the earnest money and deposits to the seller. Very different than a residential transaction right now in the broker world, which means that you have to have 2 things. You have to have a termination agreement signed by the buyer and seller with escrow instructions on how that earnest money is going to be released, whether back to the buyer or to the seller. And also in that, we have an unconditional disapproval of from the buyer, which means why are we terminating? That's happening in residential transactions right now in the real estate brokerage world in Oregon. Buyer's unconditional disapproval and a termination agreement. Here it's saying, hey, if this person did not give me a disclosure, I can take their earnest money that they put into escrow as long as they follow those instructions. Now, also, if the residential property wholesaler fails to provide a residential property wholesaler written disclosure to the seller or buyer, and if the purchase and sale agreement is terminated as a result, the wholesaler shall be liable for the damages incurred by the seller and buyer. Oh, that could be monumentally bad for the legal system for wholesalers. So make sure you understand what's going on. Also, in any mediation or arbitration proceeding or civil action between the buyer and seller, between a buyer and residential property wholesaler, and between the seller and the residential property wholesaler that arises due to the residential property wholesaler failure to provide a residential property wholesaler written disclosure before entering into written contract for a residential property wholesaler transaction as prescribed under this section, the prevailing party is entitled to recover all reasonable attorney fees, costs, and expenses incurred at trial, on appeal, at mediation, and at arbitration from the residential property wholesaler. Guys, this is not stacked in your favor. If you're a wholesaler out there and you're not following the rules, knowing your timelines, knowing how you collected proof that seller has been received, the disclosure, and you've waited the correct amount of time, and you provided buyers disclosure, everything is going to have to be mapped out in all of this. And also, it's showing you how to file a complaint. And I want to talk about complaints for a second. When we were looking at what are the penalties, guys, and let me break this down here because I took good notes. There's basically 4 things in terms of penalties that can happen. Okay, and we'll talk through the wholesaling by brokers and principal brokers here in a second, but the risks of unlicensed wholesaling include real estate agency disciplinary action. So if you're a real estate broker and you do not follow the rules, or you're a illegal wholesaler, the real estate agency disciplinary action can impose a penalty. Okay. Also, it's a Class A misdemeanor. Includes anyone that participates or any accessory. I mean, I'm talking about your dispo manager, your cold caller, anybody that's involved. It's a Class A misdemeanor. There's also civil penalty, fines plus disgorge any potential profits that you earned. That is monumentally bad for a wholesaler. Also, a bar of bringing claims unless proof of registration. So you can't countersue, file back and forth. And remember, this is not legal advice. But what it's saying is bar of bringing claims unless proof of registration, meaning you're not licensed, just like a contractor that's not licensed. They can't sue a homeowner for not paying them or doing any of this situation that they didn't follow the rules to begin with. So now let's break down a couple things. Wholesaling by brokers and principal brokers. If you're a licensed broker or principal broker who conducts residential property wholesaling, here we go with the tongue ties, you are not required to be registered as a wholesaler. However, you are required to provide written disclosure to potential buyers before entering into a contract for a wholesale transaction, to potential sellers before entering into a contract for a wholesale transaction. So just remember, buyers and sellers must be disclosed at all times that you're wholesaling this deal. To any broker or principal broker assisting somebody, so if they're serving in the capacity of their fiduciary or they're their agent, you must disclose that. And any advertising related to the property. Advertising on social media is exempt if it links to a separate page with required disclosure. Disclosure must be in at least 10-point bold font and must include a statement that the broker or principal broker is licensed and will only have or has equitable interest in the property being sold, will not have or does not have legal title to the property and therefore may not be able to directly transfer to the buyer, and might not be licensed appraiser specialist, therefore might not be permitted to provide an opinion as to the value of the property. Now, I want to talk about that. That's a little gray area. As a principal broker, I've done BPOs, broker pricing opinions. I've provided tons of comparative market analysis. So what happens if a seller calls me and says, hey, I wanted you to stop over, take a look at this property. I'm open to selling it for all cash. And you think it's a listing appointment. So you come over there with comps and you're like, hey, I think this property is worth $280,000 on the market. And then they're like, no, well, I'm thinking about wholesaling it. Guys, now there's this gray area where you've already given them value. And now you're going to have an ethics or fiduciary implied agency, or is it not a represented party? You haven't signed a listing agreement with this person, but you have to provide them an initial agency pamphlet at first contact. There's a lot of gray areas in this that they're going to have to figure out. Okay. Now, in all of that, I'm not going to go through all of this. All right. But I will tell you this. The Oregon Real Estate Forms, OREF, has already created a disclosure for wholesaling properties for real estate brokers and principal brokers. This is super important because if you have a wholesaler that reaches out and is like, hey, I have this property. I want you to list it for me. Can you represent me? there's going to be a process all around this, and there's going to be a learning curve that everybody needs to understand. And it's very important to understand what are the penalties to this and what do you have to disclose and not disclose, right? It's very, very important that you understand that there's a process around wholesaling properties. And I think what was happening in all of this is that there was no professional license. So people feel like they were getting ripped off. I've had investors that say they'll never buy wholesaling deals because they've been ripped off in terms of disclosure. And the main thing to understand this is an investor buying the wholesale contract isn't required to have seller property disclosure from the wholesaler because it's not for residential use, meaning the investor is not living in it. It's not their primary residence or for them. But if a seller is going on the market and wholesaling their property, right, to somebody who may buy it and move into it, they have to follow all these rules, right? And so that is an important thing to bring up in all of this is if you're a wholesaler, you're going to have to first figure out, and it's going to be provided, what is my disclosure statement on my website, any email communication that I have, as well as all communication when I start dialoguing with a potential wholesale prospect, as well as when I go to meet with somebody and I have them physically sign acknowledgement of the disclosure that I provided the seller acknowledgement of the disclosure. What am I going to do to make sure that I collect that proof, put it somewhere, and anytime and everybody, including escrow officers, the Oregon Real Estate Agency, attorneys, principal brokers, whatever, you have proof. You have created the cookie crumble trail that you've done everything you have possibly done. You've not provided value to the seller. You've disclosed. You've followed the 3 business days of their right to cancel. You've disclosed to any buyers or any buyers represented by brokers. You have to be able to just leave a laundry list of history and facts of what you've done to protect yourself. And this is going to cause a lot of issues, guys, because the enforcement of this, I don't know what they're going to do, right? Is there going to be fake wholesalers out there? Is there going to be sellers that are calling wholesalers to see if they don't disclose? We don't know. It's all new. This is all brand new territory. But what I want to say in all of this is, and what I learned from this attorney talking about this is that there's a lot of gray area. There's a lot of things in terms of the base regulations that are being set up that eventually probably going to be starting to be over-regulated. Now, I want to talk about the pros and cons really quick. The pros of all of this is it makes legitimate residential wholesalers, meaning if somebody's out there, they're not misleading people, they're not lying, they're not hiding things, they're not deceiving people, and they can work with an escrow and title company in a very true and professional manner. Also, there's a database of every residential wholesaler so the state can monitor who's wholesaling properties and who's going inside of people's properties where they live. If they haven't had a criminal background check, you don't want people doing crazy stuff. You don't want people saying they're a residential wholesaler and then robbing somebody's house. There's a lot of bad things that can happen. So I think that those are some of the good things. I also think disclosure is not bad, especially if you set up a formulation on how it has to be provided. The cons of this, $300 fee every year. What happens if you don't do a deal? You keep paying that $300 fee. So there's a cost involved. Number 2, the laundry list of history of proof, burden of proof, making sure that everything is signed electronically. You have records of everything. Number 3, making sure anybody that you employ is doing it properly and they're not an accessory to an issue or a complaint. That's going to be a big problem. But what I want to say is the biggest and most important thing, if you're buying investment properties and you possibly maybe be wholesaling these properties, is that you, the investor, the wholesaler, find a real estate broker that understands this stuff. That's why I was on top of it a year ago. That's why I'm on top of it, going and educating myself and listening to an attorney talk about this, because I want to make sure that each and every one of my clients has the disclosure, knows when to use it, knows the timelines and the restrictions and limitations, and understands the process, the system around wholesaling property. Because as a professional real estate activity person, somebody who's transacting, we did over 100 deals last year, over almost $40 million in transactions. I want to make sure that each and every one of my investors can, A, go to this page and read every rule. Number 2, have an advisor or somebody who can help them as a fiduciary make smart investment decisions if they're going to wholesale. So if anybody's out there in the Oregon market, or you're going to wholesale properties from a different state or buy here, hit me up. My link's going to be below. Schedule a Calendly call with me. Happy to touch base with you. You can get on my buyers list. I have over 450 buyers on my buyers list. And I will tell you this. If you remain truthful, you keep registered, you keep good records, and you know the rules and the law, you should be fine. But those bad apples who are going to break the rules, not follow timelines, they're going to either lose their earnest money, or they're going to be in court with crazy fines and a bunch of nonsense they're going to have to deal with from the legal system. So once again, my name is Dan Gandee, owner of the Operative Group. This is not legal advice. I wanted to provide you straight factual information for informational purposes only. But if you want to reach out, meet up, hit me up. Have a great day.